Hello, this is Professor Hankinson, and this is the first lecture for Topic 4, which is dedicated to the study of civil liberties. Okay, so what are we going to be covering in this lecture? The first thing we're going to do is we're going to define key terms, civil liberties and civil rights, and we're going to talk about how these two things sometimes overlap. Then we're going to take a look at the brief history of the Bill of Rights and why it is included in the Constitution as amendments rather than in the main document itself. And then we're going to talk about the concept of nationalizing the Bill of Rights. So let's go ahead and get started. All right, so let's define the key terms that we'll be learning about in both Chapter 4 and Chapter 5. So civil liberties is defined in your textbook as the individual rights and personal freedoms from which governments are constrained from interfering with. So what does that mean? Well, oftentimes when I teach civil liberties, I like students to think about civil liberties as the thou shall nots that are placed on government. In other words, civil liberties are telling government what it cannot do, what it's forbidden from doing. And in doing that, it opens a space for one's personal liberties. And we find these personal liberties in this document called the Bill of Rights, which is the first 10 amendments of the United States Constitution. And as we'll see as you're reading the chapter and as we're talking about it today, the Bill of Rights contains fundamental freedoms that are necessary for living in a democracy, such as the freedom of speech, the right to assemble, the right to have a free press. It also talks aloud about the rights of those who are accused of crimes, and it also talks about the rights of the states as well. Now, in Chapter 5, we'll be learning about civil rights. And civil rights are different than civil liberties, but of equal importance. So what's the difference between civil liberties and civil rights? Well, civil rights are the obligations that are imposed on government to guarantee equal treatment and to protect citizens from discrimination. In other words, civil rights are the demand that we place on government to ensure that everybody is treated equally in the eyes of the law. That they're not treated differently because of the color of their skin or because of their gender or because of their ethnicity or age, but they have equal protection of the law. We'll be learning a lot more about civil rights in Chapter 5, but when you think about civil rights, you think about the laws that have been passed that prohibit entities within our country from discriminating against people. And so we have civil rights laws that prohibit discrimination in employment. We have civil rights laws that prohibit discrimination in voting. We have civil rights laws that prohibit discrimination based on gender when it comes to education. Those are all examples of the obligations that we place on government to make sure that people are treated equally in the eyes of the law. Okay, I want you to take a moment now that you've learned the definitions of civil liberties and civil rights, and I want you to take a moment to think of times where the personal liberties, like the freedom to speak or the freedom to exercise your religion or the freedom of the press, might conflict with the civil rights. That is, are there times when a person is exercising their freedom of religion or their freedom of speech, or the right to be free from sort of unreasonable search and seizure that we find in the Fourth Amendment? Are there times when those things result, like a freedom of speaking freely, might result in discriminating against somebody, okay? And a sort of discrimination that the government is, obligated to protect individuals from. So just take a moment and see if you can think of any examples of the intersection or the overlapping of civil liberties and civil rights, and we'll look at some concrete examples of that in a moment. On this slide, you see two pictures. In the upper right-hand corner, you see a picture of a man who is surrounded by cakes. And on the bottom left-hand corner of the slide, you see somebody holding up a sign that says skin color is not reasonable suspicion. And both of these are examples of the intersection of civil liberties and civil rights. And let's start with the picture in the upper right-hand corner to begin with. The picture of that man, his name is Jack Phillips, and he owns a bakery, a cake shop called Masterpiece Cake Shop in Colorado. And this is a famous case, and in fact, our discussion this week is revolving around the collision or the intersection or the conflict between religious liberties and anti-discrimination law. And so Masterpiece Cake Shop is an interesting case that came to the Supreme Court. And so Jack Phillips makes cakes, makes lots of different kinds of cakes, but one of the kinds of cakes that he makes is wedding cakes. But he's also a fundamental Christian, a fundamentalist. And in his religious beliefs tell him that marriage is only between a man and a woman, that is what his religion tells him, and he follows that. That's what he believes, that he does not think that women and women and men should get married. And so this is a case where a gay couple comes into Masterpiece Cake Shop and they ask Jack if he would make a cake for their wedding ceremony. And Jack Phillips said, you know what, I'll make you your birthday cakes. I'll make you, cakes for anniversary celebrations, whatever it may be. But I will not make you a wedding cake because it goes against my religious beliefs. And Jack Phillips was sued by the two men who were asking him to make a wedding cake. And the grounds of their suit were that Colorado, and that's where the cake shop has laws on its books that says that businesses which are public accommodations, that is open to the public, are forbidden from engaging in discriminatory behavior, including discriminating against people's sexual orientation, which is if you're gay or lesbian. And so he was sued for violating the Colorado anti-discrimination laws. You'll read more about the outcome of that case in the readings for our discussion this week and also in your textbook. But that's a good example of where Jack Phillips is trying to exercise his religious beliefs, which is guaranteed by the First Amendment, but on the other side, where the state is obligated to protect people from discriminatory behaviors. The other sign there, where it says skin color is not reasonable suspicion, has to do with your Fourth Amendment rights. And so individuals have the right to be free from unreasonable search and seizure. That means that you can't be searched unless cops have probable cause, or in the case, sometimes if they're just going to pat you down, all they need is reasonable suspicion. This sign is basically saying that just because the color of your skin is black, that doesn't mean that being black poses a reasonable suspicion that justifies a search. Okay, and so that you individually have a right to be free from unreasonable search. But also the government has an obligation to protect you from law enforcement using your skin color, discriminating against you in order to search you when a search is not justified. So those are two examples of the overlapping of civil liberties and civil rights, and I want you to keep those in mind as we do both Chapter 4 and Chapter 5. Okay, let's transition now to talk about the history of the Bill of Rights. As you know, the Bill of Rights are the first 10 amendments to the Constitution. But you might be asking yourself, why are they amendments to the Constitution? That while many people in the United States do not know, if I asked somebody in the United States, what does Article 2 reference in the Constitution? Now, it references the powers of the presidency, right? You know that because you guys are studying it. But most people in the United States, if I asked what's in Article 2, what's in Article 4, what's in Article 6, they wouldn't know. They wouldn't have an idea what that is. However, when you ask somebody what's the First Amendment, they can at least tell you the First Amendment deals with the right to speak freely or the right to freedom of the press, right? If I ask people what the Second Amendment is, most people would say the right to bear arms, right? So we kind of know the Bill of Rights better than we know the Constitution, the body of the Constitution. And so you would think that why is this document that is really enumerating these fundamental individual liberties, why isn't it in the body of the Constitution? Why are these amendments to our Constitution? And there's a clear reason why that is. For one, the Bill of Rights wasn't really discussed in any detail or very little detail at the Constitutional Convention, and there are different reasons that historians give for that. But the main reason is articulated by Alexander Hamilton. And what Hamilton said is that when the question of a Bill of Rights that needed to be we should add that to the Constitution, enumerating these personal liberties or telling government what they cannot do, Alexander Hamilton's response to that was, we don't need to tell government what to do, or we don't need to tell government what they can't do when we haven't given government the power to do that, right? And so one of his favorite quotes is, "For why declare that things shall not be done, which there is no power to do," right? So why do you have to tell Congress that they can't pass laws abridging your freedom of speech when there's nothing in the Constitution that gives the national government that power? So there was a real thought that we didn't need to tell government what they couldn't do because they weren't granted that right to begin with. Well, when the Constitution went to the states to be ratified, the people at the state conventions, they weren't at the Constitutional Convention. And so when they look at the Constitution and they don't see these explicitly enumerated things that Congress cannot do, and also where there's no assurance that any power that's not granted to the federal government is left to the states refused to ratify the Constitution. Or at least enough states, we needed 3/4 of the states to ratify. Enough states said, we're not going to ratify this without a Bill of Rights, that an agreement was made that a Bill of Rights would be added. And so there was an unwritten agreement that if you ratify the Bill of Rights or the Constitution, the Bill of Rights will be one of the first acts that this newly created national government would take. And indeed, it was one of the first acts. The Bill of Rights was written by James Madison in 1789, so right at within the first session of the first Congress of the new United States under the new newly ratified Constitution. And it took a while for it to be ratified, but it was ratified on December 15th, 1791, and that's why there's a picture of a vampire there in the corner. Because why, Professor Hankinson, why is there a vampire there? Well, my birthday is December 15th, 1791. I was there for the ratification. See, I'm a vampire. I've been alive forever. That's just kind of a joke, but hey, I'm kind of mixing it up a little bit so you can have a picture of a vampire on your slides. Getting back to the subject at hand, James Madison thought the writing of the Bill of Rights was a nauseous project. In other words, it made him sick to his stomach. And you might be asking why. Well, the reason is because James Madison felt really nervous about what he was going to add in the Bill of Rights. He was really nervous that as you enumerate a right, that the right to freedom of speech or the right to religious exercise or the right to jury by trial, he was really worried about what was going to be left out, and that if something was left out, then that meant that it wasn't a right that people had. And so he viewed it as a nauseous project. It was something he did, and he did it well, but it was something that he lost sleep over at nighttime. It was a tough project for him. All right, so ask yourself, how many of the liberties in the first 10 amendments do you know? So part of the reading for topic 4 is the Bill of Rights. And that it's at the end of your textbook, but there's also a link to the internet version of the Bill of Rights that you should take a look at. But before you read the chapter, before you're looking at the Bill of Rights, maybe just ask yourself, do a pretest, how many rights in the Bill of Rights do you know? Most people know that speech is associated with the First Amendment, but there are actually 5 liberties that are associated with the First Amendment. How many of those can you name? Second Amendment, most people in the United States know what that refers to since it's such a hot topic in the United States. Fourth Amendment, Eighth Amendment, the list goes on. So anyways, just kind of do a pre-test and then maybe do a post-test after you are done with the chapter to sort of measure how much you've learned. Chapter 4 has a really nice table that you might want to take a look at. It divides the amendments up into sort of different sections that gives you kind of a good outline for how to remember the liberties that are included in the Bill of Rights. And so Amendment 1, it's telling Congress that they can't pass laws, okay? And it's telling Congress that it can't pass laws about certain things, about establishing a religion. So Congress can't establish religion. In our next set of lecture, we're going to talk about what that means. But they also can't pass laws that infringe upon or abridge your freedom to exercise your religion, your freedom to speak, to assembly, to come together as a group, or they can't abridge your right to petition the government for a redress of grievances. Basically, they can't tell you that you can't ask the government to fix something that you think is wrong. And so the First Amendment is targeted to the Congress passing laws, okay? And it addresses those five liberties. Amendments 2, 3, and 4 are targeted to not just Congress, but to all branches within our government. The legislative branch, the executive branch, and the courts as well, I guess, to a certain degree, but mostly the legislative and the executive branch. And what the Second, Third, and Fourth Amendment is saying that no branch of government can infringe on the right of the people to they can't infringe upon these particular rights of the people to keep and bear arms. They can't. The Third Amendment says that you can't arbitrarily take houses from people and give them to the militia. Okay, so it's the quartering amendment. And the fourth one is saying that government can't search or seize evidence without a court warrant swearing to the probable existence of a crime. And so the second and third and fourth are interesting because it's not just telling something to Congress, but it's also telling the executive branch that they can't do that either. Amendments 5, 6, 7, and 8 are targeted to the courts. And those are generally the liberties having to do with the rights of the criminally accused who are being either brought to court or, after being found guilty, are getting punished a post-court appearance, okay? And so I'm not going to read through all of that, but, the 5th, the 6th, the 7th, and 8th have to do with the rights that you have at trial. They have to do with the rights that you have after you're sentenced, okay? It's also telling you that while at trial, you can't be forced to testify against yourself. You can't be forced to incriminate yourself. It also tells you that you can't be tried twice for the same crime, okay? So those amendments are targeted to the courts. And then the 10th and the 9th Amendment are the amendments that limit the national government. We know what the 10th Amendment is from the last unit. The 10th Amendment is saying that any powers that are not granted to the national government are reserved for the states. And the 9th Amendment is one of my favorite amendments because it's basically saying that just because the rights haven't been enumerated in the Constitution and in the Bill of Rights, it shouldn't be interpreted that means that these are not rights that are given to the people and the states, right? And so that kind of addresses Madison's sort of nausea that he had, that hey, just because we didn't write it down doesn't mean that it's not a liberty that is granted to the people. All right, the last thing that we're going to talk about here is the concept of nationalizing the Bill of Rights. And I've got the First Amendment up there because it has that word, Congress shall make no law respecting establishment of religion, etc. Okay? And the nationalization of the Bill of Rights has to do with that word Congress. And the question about whether or not the Bill of Rights just applies to the national government or whether it applies to all sorts of government, including the state governments as well. Okay, So the question is did the Bill of Rights apply only to the federal government, or did it apply to the state actions as well? And until 1968, the answer to that question was that it only applied to federal action. And so in the Bill of Rights where it says Congress shall make no law abridging your freedom of speech, that means the national government can't do that. But if that's not in your state constitution, if your state constitution doesn't say the state legislature cannot pass laws abridging your freedom of speech or abridging the freedom of press, if it's not in your state constitution, your state government can do those things. That question came before the court in a really cool case called Barron versus Baltimore. And it was a question that came on pretty early in 1833. What we're going to learn in the next set of slides, a lecture, is that, civil liberties is about real people who feel like they've been harmed by government action, and then they feel like they need some remedy for that harm, and then they turn to the courts to say, hey, I don't think that what the government did was constitutional. I'd like you to basically remedy this bad, harmful experience, this damage that I incurred. That's exactly what happened in Barron versus Baltimore. John Barron owned a wharf. And he had boats. He had this part of the dock, the wharf, where boats would come up and then they would unload their cargo. And John Barron was like, he had the best wharf because it was really well kept. It was, he had great workers, and he had a really vibrant business on his wharf. Well, Baltimore decided that it wanted to improve its roads. And in so doing, it shoveled a bunch of dirt into the water that was right in front of John Barron's wharf. And so they were shoveling all this gravel and this silt and mud in order to lay a new kind of foundation for their roads. But that ruined John Barron's wharf. That it used to be like 10, 12, 15 feet deep, and boats could come up, and they had a lot of, there was no worry that they would get, stuck. But when the Baltimore put all this gravel in front of his wharf, it was unusable, and ships couldn't come, boats couldn't come and undock because they would get stuck. And so Barron said that he was harmed, and that what he turned to was the Fifth Amendment of the Bill of Rights, and that amendment says that government can't take away your property without just compensation, right? And so what Barron said was that Baltimore took away his livelihood, his property, right, by ruining his wharf, and that he deserved just compensation. It's called the eminent domain clause of the Fifth Amendment. Well, that question went to the Supreme Court, and the Supreme Court said that, unfortunately, the Fifth Amendment does not apply to the state of Maryland. If it was the federal government who had put a bunch of gravel in front of John Barron's, into John Barron's wharf, his property, they would have had to give John Barron just compensation for taking his property. But that Fifth Amendment provision only applies to Congress. It does not apply to the states, doesn't apply to the state of Baltimore, okay? And so unfortunately, John Barron was, excuse my language, shit out of luck, okay? His property was destroyed. There was no protection in the Maryland Constitution that said he had to get compensation for that. And it answered the question about whether the Bill of Rights applies to the state, and the answer to that question was no, it does not. That changes when the 14th Amendment is added to the Constitution in 1868. The 14th Amendment, among other things, says that your life, liberty, and property cannot be taken from you without the due process of law. But the 14th Amendment says specifically that states cannot take away your life, liberty, and property without due process of law. You can read more about that in the chapter, and if you'd like to learn more about the due process clause, feel free to email me or talk to me because I can go on and on about it. But the bottom line is that the 14th Amendment was used as an avenue to incorporate the Bill of Rights to the actions of the states. And it went liberty by liberty. And so when a state government infringed upon your freedom of speech, people brought that to the court, and the court said that, yep, the First Amendment's speech provision applies to the states. And if they applied it, that's what incorporation means. And it went liberty by liberty by liberty. So, as I stated before, civil liberties is about real people being harmed, feeling like they weren't treated constitutionally, and bringing that question to the courts. And this slide shows you that the history of the incorporation of liberties of the Bill of Rights. And so it starts with eminent domain, which was one of the first liberties to be incorporated to the states. And it goes on, and you can take a look at how long that incorporation process took place. And it still is alive, and it's still going on today. Not all the liberties of the that are found in the Bill of Rights have been incorporated to the states. On the slide, it says that the most recent one was the Second Amendment. It wasn't until 2010 that the Second Amendment was applied to the actions of the state, and that was a key case called McDonald versus Chicago. But there's actually been another liberty that has been incorporated to the states recently, and that is shown on the next slide here, which it is the excessive bail provision of the Eighth Amendment, just was recently incorporated. So this slide just shows you that which of the liberties have been fully incorporated, every liberty in the first, the total of the Second Amendment, and the total of the Fourth Amendment. And now you can move the Eighth Amendment over into that quadrant as well, because it has been fully incorporated. The Fifth and the Sixth are only partially incorporated, and so you can take a look at that. That the right to a jury selected from residents of the crime location has not been incorporated to the states. And the Third and the Seventh Amendment have never came to the court to be incorporated. And so those remain as liberties in the Bill of Rights that don't apply to the states. Okay, we'll end here by just having a couple of critical thinking questions about incorporation that you can keep in mind as we move towards our midterm exam. And so the first question is should all of the provisions of the Bill of Rights been applied to the states at once? That's what's known as total incorporation. So once the 14th Amendment was added to the Constitution that said that states can't take away your liberty without due process of law, shouldn't that have meant that all of the liberties should have been incorporated at once, at one time? That's not the way the courts did it. They decided to do it selectively, liberty by liberty, as individuals brought liberties to the court to say, hey, my state government shouldn't be allowed to do that. So maybe think about what are the advantages of selective incorporation over total incorporation. Another thing to think about is what if, just hypothetically, the Bill of Rights only applied to the actions of the federal government and that it didn't apply to the actions of the state, so that you really did have these two bills of rights that would apply to you as a citizen. So what do you think the impact of that would be on democracy? I think initially we think that would be bad, right? Because, or have a negative impact, because it would really set up a situation where, depending on what state you lived in, that some states you would have a more robust protection of liberties, and others you would have a less of a robust protection. However, maybe if we would pay more attention to our state charters, Bill of Rights charters, and add more things to it, right? But we kind of depend on the national charter for defining our liberties, and maybe that's had a limiting effect. All right, thanks for listening. I hope you learned a lot about the Bill of Rights, and in the next lecture, we'll take a look at the specific liberties that are included in the Bill of Rights.